Okay, welcome everybody. You had to be here, so, but I have to welcome you anyway, so and I do. This is going to be a great afternoon. I want to start by thanking our sponsor for this, the Faegre, Drinker, Biddle, and Reith Law Firm. This is the 6th year that they have sponsored this competition in the spring. It's been a great partnership. Not only do they give us financial support, but as you can see, 4 of the lawyers have driven down from Dallas today to participate in our final panel, and I'll introduce them in a minute. But we've gotten great support. We appreciate it, so thank you very much. I want to introduce the competitors. Y'all all know them, but the judges don't yet, so I'll tell everybody their names. And y'all know that they went through 4, well, actually, we add the practice round. After the practice round, 4 days of preliminary rounds, 3 days of post-break rounds, and these are the final teams standing. So I think we need to give them a big congratulations and tell them welcome and to have fun in this round, okay? As I was talking to them, I said, just relax, it's gonna be good, just have a good time. It's gonna be just the same as the preliminary rounds, except that there's about 90 people watching, and it's being broadcast over YouTube Live. So aside from that, it's all going to be the same, so don't worry about it. All right, so for the petitioner, we have Kate Sparks and Kaya Marie Helmer. And for the respondent, we have Keegan Kuhn and Matthew Zahn. All right, so those are your competitors. Before I begin, I also want to give some big thank yous to several people who put this whole thing on. As you can imagine, this doesn't just happen. It takes a lot of planning. We start planning for this competition way back in December, even before that. It's quite an effort to do this, you know, with 34 teams and with 170 barristers. Moving people into position every day is a big task. This spring, the preliminary rounds, we had 119 people every single day to put into position. And these people sitting over here were responsible for that, and they did a terrific job. So I want to thank all of them. Walker Montjoy, who's been a Moot Court officer for the past year. Nathan Da Silva, who's going to be the bailiff for today. He'll be back in the fall for more of this fun. And the barrister officers who are responsible for keeping up with 170 barristers, which is probably the most difficult job of the whole thing. Caitlin Gold and Olivia Murphy. So thank you guys. You did a terrific job. Appreciate it very much. Some other people I need to thank. Number 1, Susie Daniel, who was the room enforcer. She captured our rooms and held on to them with an iron fist so that nobody could come in and move us out. And by the way, if you ever have any problem that you really need a quick answer to, I suggest you go to Susie. For example, if your professor passes out in the classroom in front of you, go get Susie. That actually happened, by the way, for you guys. I'll tell you about that later. Ricky Levecki, who's done a terrific job. He's been here all afternoon setting up all the electronics, so thank you, Ricky. Nick Teixeira, who's going to be in and out. He takes beautiful photographs. The photographs he takes of these competitions are terrific, so I look forward to seeing those. Jordan Hanna and Stephanie Mabry, who are in contact with the Faegre Drinker Firm about their sponsorship, and Ed Nelson, who I know is hard at work as we speak, drafting up the social media for today. Okay, the judges, the last thing I want to talk about. Our distinguished panel of judges, of course, Dean Wilson is serving as our Chief Justice. Dean Wilson is a big fan and a big advocate for Moot Court. She's coached Moot Court teams for, you want to say how many years?
No.
Okay. Right.
A lot of years.
Yeah, so you're in good hands with the Chief Justice, I can assure you of that. Now our guests from the Faegre Drinker Firm. I'm sorry, I keep calling it Drinker, Biddle, and Reith. It's just out of habit. I worked with this firm for a long time when I was in practice. But we have to Dean Wilson's right is David Kent. I think David has joined us in every single one of these for the past 6 years. Probably. So thank you for coming back, David. To David's right is a dear friend and colleague. We worked together many years ago at the law firm of Thompson and Knight, when there was a law firm of Thompson and Knight, before it became Holland and Knight. Don McCord. Thanks, it's good to see you again. Thanks for coming. To Dean Wilson's left is Susan Eglin, and to Susan's left is Jude Hicklin, and Jude was here last year and has been here several years as well. All right. I'm done. It's time to get on with this. Dean Wilson, I will turn it over to you for any final comments, and whenever you're ready, you can call the case and we'll begin.
All right, well, I am not going to prolong this, but I do think it is important for me to also say thank you to Faegre Drinker for sponsoring this competition, because of course they do provide financial support, and thank you to the attorneys that came today to give of their time to judge this competition, so a big thanks to all of you all. I also want to say thank you to Professor Berry. In fact, I want to give Professor Berry a round of applause. If you're not aware of it, and I hope you are, that Professor Berry writes the problem that you all use for competition. And for a long time, we used problems from competitions that had occurred in the past, and they were sometimes good, but plenty of times they were not. We have never said that about Professor Berry because he gives a lot of thought to them. They're balanced problems. They're problems that give you a good intellectual workout. And so, again, not only does he run the competition and getting all the judges and keeping everything running on time, writing the problem is a tremendous effort on his part, a tremendous gift to us. So, again, thank you to Professor Berry. I also want to thank the Moot Court officers. I know you guys have had up some late evenings and keeping track of all the different scores and everything. Thank you for your time. And then finally, I want to say thank you to all the competitors. I know I'm just going to guess from past experience that there were some of you who thought, I don't want to do this. And I'm only doing it because I've had to write the brief and I might as well go ahead. I think some of you probably learned some things about yourselves that you didn't know, that either you thought you wouldn't love Moot Court and you do, or you thought you would and you're like, don't want to do that anymore. But again, thank you for taking it seriously, for taking the time to do it, and giving these guys a good workout, because I guarantee that it was not easy to get there. So congratulations. Thank you to all the competitors, and congratulations to the Final Four.
Excuse me, I omitted something very important. Two student winners from the fall competition, Rebecca Miller and Anna Jennings. I'm sorry, guys, I should have done that. When you win this competition, you get to move up, you get elevated to the bench.
It's just how it happens with the real Supreme Court. No, that's not how it happens. If only. Well, thank you again to everybody. And so without further ado, I will call the case of Fusewood versus Batesmeyer Suisse, docket number 23 CCDD. Petitioners, are you ready to proceed?
Yes, Your Honor.
All right. Respondents, are you ready?
Yes, Your Honor.
Madam Chief Justice, Your Honors, good evening, and may it please the Court. My name is Kate Sparks, and along with my co-counsel, Kaya Helmer, I represent the petitioner, Clark Fusewood. Before I begin, we would like to reserve 2 minutes for rebuttal.
Granted.
Thank you. There are 2 issues before the Court today. I will address the first, whether the defendant properly removed this case to Federal District Court from Texoma State Court using a controversial litigation tactic referred to as snap removal. And my co-counsel will present the second issue, whether the stream of commerce versus the stream of commerce plus approach should apply to the question of personal jurisdiction in a product liability case.
Counsel, before you get going, what's our standard of review?
Your Honor, the standard of review for this issue is de novo.
Is it for both issues?
Yes,
The
Your Honor.
removal issue and the jurisdiction issue?
I do believe it is for both, yes, Your Honor. Likewise, today the Court must decide whether it is willing to perpetuate the use of this statutory loophole that allows defendants with ample resources, such as Batesmeyer, to remove their case to Federal District Court despite the presence of a forum state defendant. Now, this practice, known as snap removal, is an outright display of gamesmanship that blatantly favors corporate defendants over innocent, injured plaintiffs, such as Mr. Fusewood, and effectively strips plaintiffs of their right to choose forum. It is true that prior to this case, the 5th, 2nd, and 3rd Courts of Appeal have all upheld the practice of snap removal. However, these courts rely only on a plain meaning interpretation of the statute. Therefore, today I will ask the Court to reverse the rulings of the lower courts and reject the practice of snap removal for 2 reasons. First, the forum defendant rule is ambiguous as to the appropriateness of snap removal. And second, interpreting the form defendant rule to allow snap removal produces an absurd result inconsistent with congressional intent and public policy. Moving into my first argument, the form defendant rule is ambiguous as to the appropriateness of snap removal, but proper analysis of the statute indicates that we should reject the practice. As stated in the Deutsche Bank case, a statute is considered ambiguous when it is subject to more than one reasonable interpretation. Now, the fact that there are already several prevailing interpretations of this statute coming out of the federal district courts and circuit courts is evidence enough that the statute is ambiguous. For example, per the record at page 9, several courts, including the circuit courts, have allowed snap removal based on a plain meaning interpretation of the statute. This interpretation relies on the statute's inclusion of the words properly joined and served and reads them as a condition precedent to application of the rule. On another hand, the court in Gentile versus Biogen relied on the statute's inclusion of the word any to mean that at least one defendant must be joined and served in order for the form defendant rule to apply. However, the approach that we advocate for today is that raised in Norwegian Air and in Inri Abbott Laboratories, which states that if a form defendant is served in compliance with federal rules after removal, this should then trigger the form defendant rule, meaning that if a plaintiff moves for remand within 30 days of removal after a form defendant has been properly joined and served, this remand should be granted.
The counselor, it doesn't say that in the statute, does it?
No, Your Honor.
In fact, it suggests that as long as the conditions are met, that the case can be removed to federal court, does it not?
Well, Your Honor, when read in isolation, the properly joined and served language can be construed as a condition precedent. However, given the ambiguity of the statute, it is we advocate that it is best practice for this court to consider the statute holistically and consider the congressional intent and legislative history surrounding its construction, as well as how it fits within the broader statutory scheme. So, no, Your Honor, this approach is not explicitly enumerated within the statute. However, neither is the approach of allowing snap removal. Therefore, given the several competing interpretations of this statute, we can conclude that the statute is ambiguous. And as the Deutsche Bank case noted again, when a statute is ambiguous, the court must look beyond the plain meaning of the text and consider the statute first in the broader statutory scheme, and second, in relation to the historical context and legislative history surrounding its construction. Now first, snap removal is not supported by the broader statutory scheme. In fact, when read in its totality, the removal statute is not silent on post-removal service. For example, Federal Rule of Civil Procedure 81C1 states that federal rules apply to a civil action even after it has been removed from state courts. Additionally, Title 28 of the United States Code, Section 1448, allows process to be served after removal. Additionally, Federal Rule of Civil Procedure 4M imposes a deadline for service that begins to run 90 days after removal. Therefore, when read in the context of this statutory scheme, it is clear that the removal statute does contemplate post-removal service, and that service on form defendants and that the form defendant rule should clearly permit service to occur after the case has been removed to federal district court. Otherwise, there would be no need for such rules and statutes regulating post-removal service.
Counselor, if we conclude that the language of the relevant statute is in fact unambiguous, you'd agree that nothing about what you just said really matters, right? We don't look at those other statutes. We don't look at legislative history, correct?
Actually, Your Honor, the standard of interpreting, or the canons for interpreting the statutes have often applied the congressional intent and statutory scheme to interpreting statutes even in the absence of ambiguity, and especially in the presence of absurdity or when it clearly contravenes legislative intent. Now, this leads me nicely into my next point, which is that snap removal is not supported by the historical context or legislative history surrounding its construction. As evidenced in the Judiciary Act of 1789, the form defendant rule has acted as a limitation on removal and diversity statutes since the beginning of the Federal Judicial Code. Now, the properly joined and served language, which creates the confusion surrounding the interpretation of this statute, was not added until 1948. And while the legislative history is relatively unclear regarding its addition, we can infer from the historical context and the case law at the time that the court's purpose in adding this language was to combat the gamesmanship of fraudulent joinder.
What about the three circuits that have already determined that snap removal is proper? Are you distinguishing this case from those three cases?
Yes, Your Honor, I would like to distinguish this case from those three cases, especially because Texas Brine and Gibbons, the two circuit court opinions most recent, in those cases the plaintiff conceded the ambiguity argument and agreed before deliberation even started that the statute was unambiguous. That is certainly not our contention here, and we do argue that the statute is indeed ambiguous because it is subject to so many reasonable interpretations.
On this topic of congressional intent, wasn't the statute amended in 2011, and the language that you're sort of complaining about, the joined and served language, was kept? And Congress was aware that SNAP removal was already a thing that was occurring at that time, and they could have simply removed that language if they'd wanted to, right?
Your Honor, we do acknowledge that Congress did amend the statute in 2011 and did not preclude SNAP removal. However, we acknowledge first that congressional silence on this issue or congressional inaction is certainly not the same thing as a congressional sanction. Congress has in no way expressly allowed SNAP removal.
But shouldn't we draw the conclusion that if they knew about it and they're making revisions but chose not to address SNAP removal, that in fact they essentially have sanctioned the use of SNAP removal, particularly in light of, was there not legislation considered in, I believe, the 2020 legislative session, where once again, nothing happened?
Yes, Your Honor. To the point that they knew about it in 2011, it is difficult to measure the level of Congress's knowledge on this issue in 2011, especially since in the Henry Abbott Laboratories case, a statistical study was raised showing that the vast majority of SNAP removals have occurred since 2011. This indicates that Congress would not have had the opportunity to properly contemplate the issue then because the practice was still on the rise at the time. Now, to your point that this issue was again considered in 2020, to that I would like to raise the several practical concerns that regard that legislation. First, that the year 2020 is a buzzword for all of us and that it was the year of the pandemic. And therefore, Congress has experienced several setbacks since then, and if they are to consider the issue, it is well within the realm of possibility that they are simply not able to get to it yet because of more pressing issues and because of the setbacks that even the judiciary themselves are still recovering from. Additionally, the passage of legislation such as this is subject to lobbying, which corporate defendants may exercise in order to ensure that statutes such as this one remain favorable to themselves. We are not necessarily stating that that is what is happening here. However, it is a relevant consideration in determining whether Congress has properly considered this issue.
Well, in fairness, Counselor, if we consider that, isn't it also true that the plaintiff's bar does lobbying at Congress as well, and that even though you mentioned earlier in 2011 there hadn't been as many SNAP removals as there are now, couldn't the plaintiff's bar have brought that to Congress's attention at that point?
Yes, Your Honor, they could have. However, I'm not completely familiar with the practices of the plaintiff's bar regarding this issue. Therefore, I will simply reiterate that a congressional silence is not the same thing as a congressional sanction, and that we have no way of measuring to what extent Congress has considered this issue. Therefore, the only clear congressional intent that has ever been expressed about the form defendant rule, particularly the properly joined and served language, is that to prevent gamesmanship. Now, and since SNAP—
Counselor, aren't there, you mentioned gamesmanship a couple times now, aren't there a number of ways that various parties game the rules, one could say, use the rules to their own advantage, and isn't that just good lawyering?
Well, Your Honor, it is our contention that, for example, choosing the forum best suited to your client is indeed proper lawyering and choosing what is best for your client and via strategy. However, this is different from choosing the proper forum because it requires a manipulation of the statute. As I've already stated, there is no language in the statute that expressly allows SNAP removal. And in order for defendants to get away with it, they have to consistently defend themselves that somehow it can be interpreted to allow it. It is in no way expressly allowed, and therefore we should not just simply allow it to happen because the statute does not expressly disallow it.
But Counselor, you've already started your whole argument with the point that this is an ambiguous statute and that both interpretations are reasonable. So how can you now say, well, just because it doesn't say it, that means expressly you can't allow it? You've already conceded that it's a reasonable interpretation of the language
Yes,
to
Your Honor,
permit SNAP removal.
I apologize. I acknowledge that the interpretation must be considered reasonable because of the authority behind it, because of the circuit courts that have considered the issue and have determined its reasonableness and its proper application. However, it is my contention that these circuit courts did not properly analyze the ambiguity argument because it was conceded before litigation. Additionally, as Chief Justice brought up earlier, and I responded to her question in this way, this court has, in other cases, looked to the congressional intent and the legislative history in determining how to interpret statutes. Which moves me nicely into my second point, which is that interpreting the forum defendant rule to allow snap removal produces an absurd result inconsistent with congressional intent and public policy.
Counselor, so let's say that we go with your argument and we don't allow snap removal. What are the bigger implications that we as a panel are going to have to consider when writing this opinion?
Your Honor, are you asking what are the policy considerations behind?
Yes.
Okay. Allowing snap removal offends general notions of public policy, mainly because it blatantly favors defendants over plaintiffs. This is because substantial resources are required to effectuate snap removal because it requires constant state court docket monitoring in order to immediately remove a case to federal district court as soon as it is filed in state court.
I'm sorry, where's the unfairness here?
Well, Your Honor, the unfairness lies in the fact that these large corporations have the resources and the personnel to be sitting in front of a computer 24/7.
But isn't that the nature of our legal system, that those who have resources are able to employ those resources to get the best outcome? Why would we treat this any differently?
Well, Your Honor, I respectfully disagree that we should allow this sort of gamesmanship to occur just because that's the nature of the world. I do not believe that it is the nature of our jurisprudence to allow one side to be blatantly favored in this way. But as I was saying, this blatantly favors corporate defendants over plaintiffs because they have the time and resources to do this, thereby effectively consistently rejecting plaintiffs' choice of forum. Now, especially, this also leads to non-uniform application of the statute because several jurisdictions have mandatory delays in service, meaning that a plaintiff will never, ever be allowed to effectuate service fast enough to defeat snap removal, thereby constantly being denied forum or constantly being denied their choice of forum in a case where they would otherwise be guaranteed it.
Couldn't a plaintiff just file suit against the forum defendant first and make sure they're served before adding other parties as a defendant? Wouldn't that be a way for a plaintiff to game against this rule?
In the interest of time, Your Honor, may I answer your question and then briefly conclude? Thank you. Your question speaks to the fact that plaintiffs can never beat snap removal, especially in these mandatory delay jurisdictions, because of the immediacy with which these defendants are moved to federal court. They are monitoring, and especially in this case is a great example, that we filed this case in state court, and within a day it was removed. Now, in a jurisdiction where these mandatory delays exist, where either we have to wait for the sheriff to serve or we have to wait for a docket number to serve, in these situations it would be physically impossible for us to serve a forum defendant fast enough to defeat this snap removal, thereby consistently and constantly denying us our choice of forum in a case where we would otherwise be guaranteed it. For these reasons and the aforementioned, we ask the court to reject the practice of snap removal and reverse the rulings of the lower courts. Thank you.
Thank you.
Chief Justice, and may it please the court. My name is Kaya Helmer. As my co-counsel, Ms. Sparks, told you, I will be addressing the second issue before the court today, arguing on behalf of the petitioner that the stream of commerce approach is the correct approach to the question of personal jurisdiction in a products liability action, and that as such, we ask that this court reverse the holdings of the lower courts. Now, this issue before the court today is about protecting the American consumer, but more specifically, it's about foreign manufacturers who are welcomed in through the front door of the American marketplace, but allowed to sneak out the back window when they cause harm to those American consumers in our own home. Now today, we simply ask that this court hold all players in the American market accountable and not leave the back window open for foreign manufacturers to escape through. Instead, we ask that this court adopt the stream of commerce approach to the question of personal jurisdiction for three main reasons. Number one, that this approach is consistent with the nature of modern commerce. Number two, that this approach is consistent with the purpose of the minimum contacts requirement. And number 3, that this approach is consistent with the underlying products liability action. I'll be addressing each of these in turn, starting with the first, that the stream of commerce approach is consistent with the nature of modern commerce. Now, we anticipate that respondents will tell you that foreign manufacturers who sell their products in the United States typically do so through a domestic distributor, and that as a result of these distributorship agreements, the foreign manufacturer does not target any specific U.S. state, but rather the United States as a whole. This demonstrates the exact problem with the respondent's stream of commerce plus approach, as foreign manufacturers will never meet that additional targeting requirement set forth by the stream of commerce plus approach. Instead, they are allowed to use these domestic distributors as their puppet and their shield from liability. This is the exact problem that Justice Ginsburg found the last time this issue was before this court in the 2011 Nicastro case, in which she found that the stream of commerce plus approach allows these foreign manufacturers to pilot-like wash their hands of their products and the product liability. But this was not only the facts of that Nicastro case, but is also the facts of this case before the court here today. As per the record on page 4, the respondent, Bates Meyer's CEO, explicitly stated that the goal of their distributorship agreement was to gain access to the United States while minimizing their risk of being sued here. So instead, we see that the nature of modern commerce supports the stream of commerce approach. Now, in the case of international life insurance, this court upheld the stream of commerce approach for 2 main reasons.
Can I ask a question? What rule are you exactly advocating for? When you say stream of commerce, is this a rule that applies only to the manufacturer? Does it apply to those who provide component parts? To whom are you advocating this stream of commerce rule would apply?
Yes, Your Honor. Under the stream of commerce approach, there is a 2-step analysis. This is according to the court's initial holding in Worldwide Volkswagen and has been repeatedly upheld in different opinions since then. Under the stream of commerce approach, the 2 requirements are, first, that a member of the stream of commerce has intentionally placed the product into the stream of commerce, and second, that they have the knowledge and foresight that that product will end up in the forum jurisdiction. So this can include manufacturers of various end products.
Would it apply to those who, again, I just want to understand what rule you're advocating for. Would it apply to those who provide component parts?
It could, Your Honor, potentially, as long as they have that requisite knowledge that their product, their end product that they have produced, would reach the forum jurisdiction by placing it into the stream of commerce.
And if we look at manufacturers, how do we know what they foresee? Is everything potentially foreseeable? In which case, it would seem like this rule probably does violate minimum contacts or something, because again, foreseeability just seems like it's too light of a standard.
Your Honor, to that, we would point you back to the facts of this case, which are similar to the facts of Nicastro, Asahi, Worldwide Volkswagen, the progeny that we're referring back to, which show that members in a stream of commerce typically have contractual agreements in which they can agree where their products will be sold.
But then isn't that the plus that would, even if we were to adopt a stream of commerce plus, would result in personal jurisdiction? So that in fact makes sense, as opposed to just this broad, you manufactured something and put it in the stream of commerce, and therefore you're subject to the personal jurisdiction of, everybody, every state.
Your Honor, here the contract at issue is not subjecting, under the stream of commerce plus approach, is not subjecting the manufacturer to jurisdiction because they did not target any specific state. The plus in the stream of commerce plus approach is effectively isolating these foreign manufacturers from liability because they target the United States as a whole rather than any specific jurisdiction.
Excuse me, Counselor, I thought you said the second step in Worldwide Volkswagen was that they had to reasonably anticipate the product would enter this forum, not just the United States, but the forum in which suit was filed. So it sounds like you just contradicted yourself by saying as long as it goes into the United States, that's good enough. How do we satisfy? How does this case satisfy your second prong?
Well, Your Honor, to that, I would point the court's attention to the purposeful availment definition, which is how this court has decided that they will establish that minimum contacts have been required in international shoe. Under the purposeful availment, what you're looking for, or how this court has defined purposeful availment, is by intentionally invoking the benefits and protections of a jurisdiction's laws. Now, by this contractual agreement, we see that the manufacturer was anticipating and hoping for business in all 50 states, but without the specific targeting of any specific state. So they have invoked the benefits of the laws of the jurisdiction. They just simply fail to meet that specific targeting requirement, which is how they're able to isolate themselves from liability. Now that brings me into my second point, which is that by invoking the benefits of a foreign jurisdiction and yet skirting its laws, this court has already held in Burger King v. Rudziewicz that that is a violation of fair play and substantial justice, which in international shoe, this court determined was the purpose of the minimum contacts requirement. It also held that invoking the benefits and protections of a foreign jurisdiction's laws is how you evidence that purposeful availment. Now, my third point is that
But again, counsel, you've just said that we're not focused on any jurisdiction. We're not going to avail ourselves of the benefits of any jurisdiction. We're going to do it to all jurisdictions in general. So how do you get to the connection? Why doesn't it offend the notions of fair play and justice if they are not targeting the forum jurisdiction?
Well, Your Honor, to answer your question, there's a distinction to be made between invoking the benefits of a jurisdiction versus specific targeting. Now, invoking the benefits, as this court held in Burger King, can include reaping the economic benefit of selling your product in that jurisdiction, and intentionally so. However, the additional targeting requirement under the stream of commerce plus approach can look like many different things. This additionally, I'll move to this point now, as part of the problem with the stream of commerce plus approach is that it lacks predictability. That plus part, that additional conduct targeting a foreign jurisdiction, can look like a variety of different things. In both the Nicastro and Asahi opinions, Justice Kennedy and Justice O'Connor respectively make long, non-dispositive lists of examples of the various types of conduct that can satisfy that additional targeting requirement. Now, this is material because this court has already decided in Worldwide Volkswagen that potential defendants are entitled to predictability. In other words, they are entitled to some minimum assurance as to where their conduct will or will not render them liable to suit.
Well, the minimum assurance, the predictability you're espousing here is that they will be subject to jurisdiction everywhere. So it eliminates any of the predictability rules and examples that were cited by Justice Kennedy. Just say, well, forget it. You're stuck. You have no defense. Seems to me you're letting the exception swallow the rule.
Well, Your Honor, it's petitioner's contention here today that there is predictability and that there is a bright line rule. And the inherent vagueness and need for the stream of commerce plus approach to continually adapt to the ever-changing globalization and commerce would only create more vagueness and less predictability for these potential defendants.
Well, it's really more vagueness and predictability for the plaintiff. The plaintiff doesn't know whether or not it's going to have jurisdiction over the defendant. The predictability you're talking about, the defendant is not benefiting from your rule whatsoever. The defendant is losing any protections. At least now it has some questionable, by your analysis, protection.
While that may be true, Your Honor, that the defendant is losing some of that isolated liability, it's petitioner's contention that this does not violate the traditional notions of fair play and substantial justice, which brings me to my third point, that this...
Counselor, before you go to that third point, I'm concerned with, I'll give you a hypothetical scenario. A small manufacturer here in this state decides, I'm going to start selling some goods online or locally even. Now, shouldn't they be able to foresee that it could end up not just in any of the 50 states, but in a foreign country? And doesn't it violate those same traditional notions of fair play and substantial justice to say that that mom and pop shop could suddenly be hauled into court thousands of miles away in a jurisdiction they're not familiar with? and never specifically targeted?
Your Honor, I'm going to make a distinction from that hypothetical in that hypothetical, there is an American seller who is potentially being hailed into court abroad, outside of the U.S., which would involve the jurisdictional rules of a foreign country.
Well, let's just talk about a seller that could be hauled into court in the state of Maine from thousands of miles from its home state. Let's just stick to that scenario. Wouldn't your rule allow that? I mean, wouldn't they be subject to jurisdiction in any of the 50 states where its product ended up?
Yes, Your Honor, so long as they had the requisite knowledge that the product could end up in that jurisdiction, that would be the case.
But isn't that always the case when someone's selling something online and people are just clicking and doing that? It could be someone in Maine, it could be somebody next door. So the answer to that question is yes, they would be subject to the personal jurisdiction of, well, Maine, since we've been talking about that state.
Yes, Your Honor, that is the case. Now, the reason that Petitioner is contending that this does not violate the fair play and substantial justice is by the effect of these two different rules. Under the stream of commerce plus approach, the manufacturer would be isolated from liability, meaning that the typical defendant in a product's liability action would no longer be liable to suit. Now, in American jurisdictions, this can leave one of two different effects. In a minority of American jurisdictions, you have innocent retailer statutes, which recognize that it is typically the manufacturer who has the opportunity to design and manufacture these products as well as inspect and test them. But under the stream of commerce plus approach, that manufacturer is no longer subject to suit. So instead, there is an innocent retailer statute protecting the retailer, as they were not the party who had that same ability to manufacture and design the product.
But shouldn't our constitutional analysis not be impacted by the individual policy decisions of specific state forums? Are you suggesting that because some states have laws that might mean that these plaintiffs are left without a defendant to sue, that means we should ignore the principles of all the due process cases that have come before?
No, Your Honor, that is not Petitioner's contention. For the sake of time, Chief Justice, may I answer the question and then briefly conclude?
Yes.
Your Honor, even in jurisdictions without these innocent retailer statutes, you would then, the other side of that in the majority of U.S. jurisdictions is that the effect of the stream of commerce plus approach is that these retailers who did not have the opportunity to design or manufacture the good would then be left out to dry. In either situation, you have an American party being left holding the burden of a defective product built by a foreign manufacturer. We are not contending that products liability law should then govern jurisdiction, but simply that the effects of these two different approaches must be taken into consideration as public policy arguments. For these reasons and the aforementioned, we ask that you reverse the holdings of the lower courts and apply the stream of commerce approach to the question of personal jurisdiction. Thank you.
Chief Justice Wilson, Your Honors, may it please the Court. My name is Matthew Zahn, and together with my co-counsel, Keegan Kuhn, we have the privilege of representing the respondent in this appeal. There are two issues in this appeal. First, I will explain why snap removal is appropriate under the plain language interpretation of 28 U.S.C. 1441b2. And second, my co-counsel will evaluate whether this Court should adopt the stream of commerce plus approach to personal jurisdiction in a products liability suit involving a foreign manufacturer. This Court should affirm the appellate court's denial of Petitioner's motion to remand for three reasons. First, the plain language of the statute unambiguously permits snap removal. Second, interpreting the language of the statute to permit snap removal does not produce an absurd result in light of the statute's overall structure and purpose. And third, reasonable minds could conclude that the procedural effects of the statute require a change in the law. If, however, such a change is required, it is Congress and not the judiciary that must act to resolve it. This appeal is ultimately about fairness and predictability. The facts of our case, noted on page 6 of the record, involve Respondent, a non-formed defendant, removing the case from state to federal court before any defendants had been served with process. including an in-state co-defendant. This first issue is one of statutory interpretation, and any exercise in statutory interpretation begins with the words of the text. If the words of the statute are unambiguous, the statute should be enforced as written, unless it produces an absurd result. 28 U.S.C. 1441b2 provides that a civil action otherwise removable solely based on jurisdiction under 1332a may not be removed if any party in interest properly joined and served as defendants is a citizen of the state in which the action is brought. And this brings us to our first point, which, as page 10 of the record indicates, the 12th Circuit Court of Appeals agreed with our country's 2nd, 3rd, and 5th Circuit Courts that this plain language unambiguously permits a defendant to remove a case from state to federal court before any forum defendant has been served with process.
But Counselor, apart from the text of a statute, aren't we supposed to consider the purpose of the statute, the legislative history, and the context in which that language falls?
Yes, Your Honor. And the only reason that we will look outside of the language that's under scrutiny is if it produces an absurd result. It's our contention that the language is unambiguous, and so there's no need to look at congressional intent. We will take a look at that today, however. Your Honors, even courts which have rejected snap removal usually determine that the language is unambiguous in permitting it. The only courts to rule that the language is ambiguous have engaged in a hair-splitting semantic analysis known as the Hawkins approach. The problem, Your Honors, with the Hawkins approach is it creates unfairness and a lack of predictability for plaintiffs and defendants alike. The Hawkins approach developed before Congress amended the language of the statute in 2011. At that point, the language of the statute read something to the effect of, a case may be removed so long as none of the parties in interest properly joined and served as defendants is a citizen of the forum state. The Hawkins court accused courts which had upheld snap removal of confining their textual analysis too narrowly to the properly joined and served language. But then the Hawkins court turned around and used the same logic and confined it even further by only looking at the word none. The rationale of the Hawkins court was that they wanted to give effect to every word so as to leave none superfluous, and they determined that the word none referred to the parties in interest and extrapolated from this that Congress must have meant not that some properly joined and served forum defendant could exist, but that one must exist in order for the statute to take effect. Your Honors, if this type of underhanded approach is permitted, then it leaves the plain language of the statute potentially susceptible to as many interpretations as there are judges or lawyers to take up the task of interpreting it. Instead, this court needs to protect the reasonable expectations of the average plaintiff or defendant who won't be engaging in this kind of verbal acrobatics, but instead will be relying on the plain language of the statute when they become parties to a suit. As Petitioner mentioned, courts have continued to rely on the Hawkins approach even after the language of the statute was amended in 2011, such as the court in Gentile versus Biogen out of the District of Massachusetts in 2011. Instead of looking at the word none, they looked at the word any and came to the same result. Petitioner also mentions cases out of the District of Illinois, which included including the Norwegian Air Shuttle case and In re Abbott Labs, who apply the same logic that comes out of the Hawkins approach to cobble together other language of the statute, looking out of 1441b2, which it's our contention smacks more of a court being dissatisfied with a procedural effect and trying to find some way to make the means justify the ends that they're looking for.
Don't you agree, Counselor, though, that the language in the statute assumes that at least one defendant has been served?
No, Your Honor, it's our contention that there is no assumption, and this is precisely the problem with the approach, the Hawkins approach, which is the approach that Petitioner is proposing. Petitioner said that there's no language in the statute that expressly allows it, therefore it should not be permitted. And I would say if we agree with that, but I would say that if there's no language that expressly permits the approach that Petitioner is proposing, which is bringing together language from other areas of the statute in order to justify post-service removal necessitating a remand.
What about the word any?
Yes.
Is that?
Yes, Your Honor. I think
Wouldn't that be superfluous if we?
No, Your Honor. It's our contention that it's not superfluous. A more reasonable interpretation of Congress's addition of the word any was proposed by the court in Life Point versus Wellcare when they said, What Congress was doing in adding the word any was actually trying to create a plaintiff-friendly approach by lowering the threshold so it's such that plaintiffs need only join and serve one form defendant in order to prevent removal. Before Congress adjusted the language, there was confusion about, well, if none, what does that mean? Is it all of them? Is it only one of them? So,
Well, how could it possibly be plaintiff-friendly if the effect is to give a defendant the opportunity to defeat the plaintiff's choice of forum and to defeat the purpose of diversity jurisdiction, which is a limited jurisdiction, not a presumptive jurisdiction?
yes, Your Honor. As this court mentioned, plaintiffs, petitioners were not without options in this suit. They did not exercise their ability to first properly join and serve the forum state defendant Whiteberry before effecting service on non-forum defendants. Doing so could have prevented any removal before service on any of the other defendants. And this brings us to our second point.
I would suggest that, all in all, your interpretation is exactly the kind of gamesmanship that the petitioner referred to. And to outdo it, you have to be a better games player over something that seems entirely inconsistent with Congress or our legal system in general, giving plaintiffs choice of their form. And that, as was suggested, it favors those who have the resources to sit and monitor state courts. Surely that can't be what this statute was supposed to do, was it?
Your Honor, I guess we want to make a distinction. Would you actually mind just repeating or clarifying your question for me, if you would?
Well, I'm just saying that Congress surely did mean to encourage gamesmanship on both sides, as opposed to some purpose that promotes justice. When it wrote this provision, when it amended it, so what is the purpose of this statute then? Was it really meant to allow snap removal?
Your Honor, it's our contention that allowing the snap removal is in line with congressional intent. And this involves looking at whether or not there's absurdity that arises. And
But who benefits from allowing snap removal beside the defendant?
Your Honor, to look at congressional intent a little bit, it involves the question of absurdity. And many courts have, when they look at the question of absurdity, agree that the bar for absurdity is a high one, as it should be. Some courts have defined absurdity as something that must be preposterous, something no reasonable person could intend. Other courts have defined absurdity as something that's patently illogical or contrary to congressional intent.
How does this promote an orderly judicial system when you interpret it as allowing snap removal before service has occurred on any defendant?
Yes, Your Honor. If congressional intent is one of the bars or benchmarks that we use to understand what absurdity means, it begs the question, what did Congress intend by the language of the statute? Well, the power of removal has existed for defendants since the Federal Judiciary Act of 1789. The rationale behind removal was to permit a defendant to escape any potential in-state bias when they were hailed out of their own state and into another. So, for example, if a California plaintiff sued a Texas defendant in a California state court, under the right circumstances, the Texas defendant would be able to remove the case from state to federal court to achieve a less biased forum. Now, Congress amended the language of the statute in 1948, adding the properly joined and served language in what has become known as the forum defendant rule. Although Congress was not explicit as to their reasons for amending the language of the statute, courts and commentators agree that there are at least two primary purposes behind the language of the forum defendant rule. The first was, of course, to prevent a practice known as fraudulent joinder, whereby plaintiffs searching for a more favorable forum would join an in-state defendant against whom they had no intention of pursuing a cause of action, and then once the window for removal had closed, would dismiss the forum state defendant, thus preventing removal. If preventing fraudulent joinder is one of the primary purposes behind the properly joined and served language, then permitting a defendant to remove a case from state to federal court before any forum defendant has been served does not make fraudulent joinder any more likely to occur or difficult to identify, and thus the practice of snap removal does not directly contradict the properly joined and served language.
Well, actually, doesn't it completely contradict the purpose? Fraudulent joinder is fraudulent joinder. Snap removal occurs despite proper joinder. There's no fraudulent joinder, but by being fast and having a lot of money and resources, I can defeat the plaintiff's choice of forum against a properly joined, non-fraudulent forum defendant, and I can expand this limited jurisdiction. You still haven't answered how that snap removal promotes either purpose.
Yes, Your Honor. We think that the court in Gibbons put it well when they said that Congress may well have been using the properly joined and served language both to limit plaintiffs' gamesmanship and to provide a bright line rule keyed on service, which is much more easily administered than a fact-specific inquiry into a plaintiff's subjective intent as to why they join any particular defendant. In other words, what Congress is doing is what Congress does all the time, which is engaging in a policy-making decision which often requires balancing distinct and competing interests, as here, on the one hand, preventing plaintiff gamesmanship via fraudulent joinder, and on the other, preserving a plaintiff's choice of forum. Disputes arise, however, in situations where a forum defendant sued in his own state removes a case from state to federal court. Notably, the facts of our case involve a non-forum defendant and a defendant from outside of the United States that removes a case before any defendants have been served with process, which is precisely the situation that Congress imagined when they created the power of removal for defendants. And this brings us to our third and final point, which is that reasonable minds could conclude that the procedural effects of this statute require a change in the law. If, however, such a change is required, it is Congress and not the judiciary that must act to resolve it. Why is this not simply a question for the courts to decide? Because in 2011, Congress completely overhauled the language of the statute, and they specifically chose to preserve the properly joined and served language, despite the fact that snap removal was a reality in 2011. And it is well settled that where Congress amends some language of a statute and chooses to leave other language unamended, courts are to interpret this as either Congress is satisfied with the unchanged language or at least tolerant of its inadequacies. I direct this court's attention to page 13 of the record, where a footnote indicates that a bill has been pending before a subcommittee of the House Judiciary Committee for the last 4 years, in which a new amendment to the language has been proposed, which could affect the future of snap removal. The day may come when Congress decides to amend the language of the statute again, but unless and until that day comes, it is incumbent on this court to uphold the plain language of the statute in permitting snap removal. For these reasons, this court should affirm the appellate court's denial of petitioner's motion to remand. Thank you.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Keegan Kuhn, and I'll be continuing arguments on behalf of the Respondent, urging the Court to adopt the stream of commerce plus approach to personal jurisdiction in products liability cases involving a foreign manufacturer. Your Honors, this is a case about certainty, predictability, and foundational constitutional protections. We are asking the Court to adopt the stream of commerce plus approach, thus affirming the decision of the lower court for two main reasons. First, adopting the stream of commerce plus approach would remain consistent with this court's previous interpretations of the Due Process Clause. Second, the stream of commerce plus approach better aligns with the consistent policy perspectives of this court. Now, before moving into arguments, I want to take a moment to outline the exact test that we are asking the court to adopt for the sake of clarity. The stream of commerce plus approach was first introduced by Justice O'Connor in her plurality opinion in the Asahi case. And beyond the mere foreseeability required by the stream of commerce approach, the stream of commerce plus approach requires an additional action by the defendant that is purposefully directed at the forum state. Now, Justice O'Connor provided a few examples of what this might look like in her plurality opinion. For example, a defendant could design its product for a particular market in a particular forum state, or it could advertise in a forum state. Perhaps a defendant establishes channels for consistent communication with customers in the forum state, or they agree to market through a distributor that agrees to serve as a sales agent in the forum state. It's important to note that this is not an exhaustive list, but they do provide the court with some guidance as to the type of conduct that would constitute an additional directed action toward the forum state. And the important takeaway here is that all of these actions imply the need for a form of relationship between the defendant and the forum state. This leads into my first point. The Stream of Commerce Plus, adopting the Stream of Commerce Plus approach would align more consistently with this court's previous interpretations of the Due Process Clause. And this is best demonstrated through moving chronologically through the cases in which this court has considered the implications of due process on personal jurisdiction. Starting at the beginning with International Shoe. It's famous for its introduction and creation of the minimum contacts test, but it was truly revolutionary for acknowledging that relationship between the defendant and the forum state and also the litigation. The court reaffirmed this idea.
Counselor, here's the problem I'm having, is that if we were to adopt your construction of the concept, what it takes to have personal jurisdiction, you get exactly what the petitioner suggested, which is they get the benefit of selling goods in the U.S. market without ever having personal jurisdiction in any state, even though they meant to sell in every state. What's wrong with that argument?
Your Honor, it is not respondent's contention that in this case, or in any case necessarily, that under our approach, an international manufacturer would be completely immune from liability anywhere in the United States.
But if we rule your way, are we not sending the message to particular international sellers, just do a distributorship where you say we want you to sell our stuff all over the U.S., but we're not targeting any particular state. You sell where you want. Wink, wink.
Respectfully, Your Honor, I don't think so. The approach that we are asking the court to adopt is more consistent with the due process considerations that this court has previously instituted and proposed, in that basing personal jurisdiction, say, on the expectations or on foreseeability, as proposed under the Stream of Commerce approach to personal jurisdiction, is inconsistent with the idea that personal jurisdiction is based on the actions of a defendant and not just the expectations or the foreseeability that a particular defendant might have. This ties into some of my arguments about the policy considerations in this case. This court rightly pointed out that there are issues with the foreseeability standard under the Stream of Commerce approach proposed by the petitioners. Frankly, the foreseeability proposed is an uncertain standard. It's unclear as to whether this is a subjective foreseeability in terms of the particular defendant at issue, or if this is a more objective reasonableness of foreseeability, as would be applied in other areas of the law.
Counsel, is it your position that the Stream of Commerce approach exposes companies to liability unfairly?
Yes, Your Honor, potentially, because of the idea of those traditional notions of fair play and substantial justice. Under the Stream of Commerce approach, as Your Honor rightly noted, there is potential for smaller defendants, unlike the defendant in this case, to be exposed to liability in extremely distant or inconvenient forums.
Don't they have the ability to minimize those risks, though, in other forums, like through, say, insurance or things like that?
Yes, Your Honor, depending on the size of the defendant. And I'm glad you bring up this idea of minimizing risk. Petitioner introduced the quote from page 4 of the record from the CEO of the Respondent, Batesmeyer, in which he expressed the desire to access the U.S. market while minimizing the risk of suit. A common theme in this case is the idea of gamesmanship. However, it is our position that this desire to minimize the risk of suit is not an instance of gamesmanship any more than was employed by the petitioner in this case as well. Rather, we would contend that it's smart business planning and strategic legal planning. A footnote in the record indicates that the petitioner in this case chose the forum of Texoma because of its more favorable products liability laws. Petitioners contended that this should be allowed, as this is strategic legal planning. However, when the defendant, or in this case the respondent, engages in these activities, it's considered gamesmanship. Respectfully, Your Honors, this type of strategic...
Is there a difference here, if we're looking at it from a fairness standpoint? When you have a defendant who really has wanted, so it seems, to sell its products in the United States, yes, maybe it's subject to the plaintiff's gamesmanship of picking a particular state. But the plaintiff's option, if we go with your rule, is to go to a foreign country to pursue liability because they got hurt by a product that they just happened to buy. So what are they getting in return for having to go overseas to sue?
Firstly, Your Honor, if I may respond to the point that plaintiffs would be forced to go into an international forum. It's not our position that our client would be invincible from suit anywhere in the United States. If we look to the Burger King case, we think a similar situation might exist here, where the act of creating a contract and the negotiations that went into that with High Sports, a Colorado-based company, and the subsequent shipping of products from our client to High Sports, that Colorado-based company, could be the additional directed action that would subject our client to suit in the state of Colorado. So there is at least the potential for relief within the United States.
Isn't it definitely foreseeable that that company in the United States would then sell it to people in other states and then maybe even resell it? You know, you might have some person who buys it there and then resells it to somebody in another state. I mean, that's pretty foreseeable, isn't it?
Well, Your Honor, respectfully, it depends on the standard of foreseeability that this court chooses to employ. As I mentioned, the potential for subjectivity in these foreseeability determinations remain unclear. Further, under the test that we are proposing is correct, which would be consistent with the idea of purposeful availment and the need for a substantial connection between the defendant and the forum state, that foreseeability that the distributor of its own accord might distribute that product to different states within the United States would not be enough to subject the manufacturer of that product to personal jurisdiction based on the decision, the independent decision of that distributor. Chief Justice, if I may return to your comment on fairness in this case. The flip side of policy considerations in this case is exactly that, a consideration of fairness. But I encourage the court to remember that with respect to the issue of personal jurisdiction, the fairness considerations are considerations of fairness for the defendant. This is evidenced through those traditional notions of fair play and substantial justice that were introduced in International Shoe and the factors that go into that determination that were later introduced in the Worldwide Volkswagen case. Notably, the main primary consideration in that determination of whether or not personal jurisdiction would offend the traditional notions of fair play and substantial justice is the burden on the defendant. This sole primary factor is weighed against factors like the plaintiff's ability to gain relief or the forum state's interest in resolving a dispute that may have happened within that state's borders. The fact that this primary focus is on the burden of the defendant demonstrates that that one factor is weighed against all of these others, demonstrates that the focus of fairness here is on protecting defendants.
Well, you may focus on that, but it doesn't exclude a forum state's interest in protecting its citizens from injuries caused by out-of-state actors.
Correct, Your Honor. It's not our position that it does exclude. I was merely using those factors as a demonstration that the priority of the court in a case like this should be protecting defendants and prioritizing, considering the burden on defendants. With respect to the idea of states potentially having an interest in resolving the disputes that happen within the borders of that state, it's important to look to the idea of state sovereignty. Justice Kennedy brings this up in his Nicastro opinion. And it's important to remember that the ideas of state sovereignty and those fairness and protection considerations for the defendant that I mentioned are not mutually exclusive. In Worldwide Volkswagen, this court noted that due process considerations with respect to personal jurisdiction concern both fairness for defendants and protecting defendants through the limitations of excessive state power.
Counsel,
state overreach.
you are mentioning fairness quite a bit. And here, Batesmeyer is a Swiss corporation, right? We have a foreign corporation. However, we see that Batesmeyer has no employees, representatives, no place of business or offices in the United States. So I'm struggling to see that, I'm struggling to reconcile these two things of, you know, we're supposed to have fairness for the defendant, yet we see on the record that this foreign corporation has nothing here in the States but hiding behind this domestic company in Colorado. So how am I supposed to reconcile these ideas of fairness, yet when this seems like blatant gamesmanship here?
Respectfully, Your Honor, on the issue of gamesmanship, we would return to the idea that both sides of this case are employing strategic legal planning and counseling. With regard to your question on fairness, it is our contention that the facts that you bring up, noted on pages 3 and 4 of the record, about the fact that Batesmeyer has no employees here, the fact that it has no stores here, the fact that the distributorship agreement with High Sports explicitly leaves activities like advertising and marketing to the distributor, if anything, weighs the fairness factor in favor of the respondent Batesmeyer. Would it be appropriate when all of these things are not present, more specifically, they took it upon themselves to contract around this and explicitly leave these activities to the distributor in this situation? Would it be appropriate, would it be fair to subject them to personal jurisdiction in this forum state?
But didn't they know that the product would end up here?
Well, Your Honor, what do you mean by no? This goes back to the issues with foreseeability determination.
Well, they didn't set up a scheme with a distributor in this country to distribute it to the 50 states because they thought it wouldn't end up in all 50 states, right?
No, Your Honor. But
So they knew it would end up there. So I'm struggling to see how it's unfair to them if they want to ultimately, their goal is to sell products here, how's it unfair that they be hauled into court to answer for a defect in their own product?
Your Honor, we would respectfully disagree with the idea that they knew for certain that the product would end up here. At most, when entering the distributorship agreement, they might have expected or hoped for sales wherever those sales might come, but they certainly did not target the state of Texoma within that distributorship agreement.
No,
They would certainly benefit, right, from more sales in more states, in more jurisdictions. I mean, that's certainly something that, like you said, they would have hoped for and wanted and actually do benefit from, isn't it? Is that the case?
Your Honor, it's unclear with respect to the facts of this case where that benefit would come from. Noted on page 4 of the record, the defendant Batesmeyer shipped its quantities of the Skynet harness directly to the distributor, who in turn resold the product. So it's unclear as to whether or not our client, the respondent, would be concretely aware of those benefits at the time of sale, or whether or not that would fall strictly to the distributor, High Sports.
They knew the distributor, though, was going to sell the product, right? They didn't sell it to the distributor thinking the distributor's going to just hold on to it.
That's correct, Your Honor. If I may return briefly to your point on the idea of benefits, petitioners brought up the purposeful availment requirement. And it's important to note here that in Burger King in 1985, this court clarified the purposeful availment requirement to, and I quote, exists where the defendant deliberately has engaged in significant activities within a state or has created continuing obligations between himself and the forum. This idea of a benefit being incurred is the staple of this purposeful availment requirement. But this court, as I just read, requires an action by the defendant himself to create that purposeful
But counsel,
availment.
you stated that something such as advertising is sufficient to satisfy that second prong. In modern commerce, where do we draw the line? Is advertising posting something on a website? How is not everyone then lumped into that category with modern commerce as it is?
Your Honor, I see I'm out of time. May I briefly answer the question and conclude? Your Honor, the question of how this would apply in modern economics is a good question. And this court has not considered the implications of something like the internet on this analysis, whether the court adopts the stream of commerce approach or the stream of commerce plus approach. The most indicative case on issue is actually the Zippo case, which is a district court ruling, but multiple federal appellate circuit courts have relied on that analysis. And what that case essentially requires is the consideration of certain factors with regard to what that online activity looks like. Is there something on the website or on the post that indicates a targeting of the forum? Or is it a more generalized website that just displays information? And so it would, under our approach, it would require a factual analysis based on the case-by-case approach of what the particular online activity looks like. We ask this court to adopt the stream of commerce plus approach, thus affirming the decision of lower court, reaffirming principles of certainty and predictability. Thank you.
Thank you.
May it please the court. Petitioner brings two issues on rebuttal. First, I would like to acknowledge that, as Respondent noted, the bar for absurdity is indeed quite high. However, this issue rises to that level of absurdity for the policy reasons that I listed in my main argument. SNAP removal favors corporate defendants, it effectuates non-uniform application of the forum defendant rule, and it contravenes clearly expressed congressional intent to prevent gamesmanship. Additionally, Respondent noted that Congress does have the duty of writing and enacting statutes. However, it is the express duty of this court to interpret such statutes, and has a long history of doing so. We are merely asking the court to interpret the forum defendant rule within the scope of its power and according to its pre-existing principles of statutory construction. Additionally, Respondent took great care to explain the any argument, also known as the Hawkins argument, and its many inadequacies. We would like to point out that we in no way advocated for this approach. On the contrary, we advocated for the Abbott approach, which would allow the forum defendant rule to apply even when service is effectuated after removal. Respondent stated that this approach is a amalgamation of the language of the statute and rearranging the words in a way that benefits us. However, this is not the case. This approach advocates for applying this rule in accordance with the pre-existing federal rules governing remand and removal. The benefit of the Abbott approach is that it requires no new statutes, it requires no new interpretations. We simply apply the pre-existing rules and allow a plaintiff to remand their case if they served a forum defendant properly. Finally, Respondent is using their financial prowess to ignore the plaintiff's choice of forum and isolate themselves from liability, effectively leaving Petitioner without remedy, unemployed, paralyzed, all as a result of Respondent purposely selling a defective product in the United States. This shall not stand within our jurisprudence.
Well, she does have a remedy, the plaintiff does have a remedy, just maybe not in this state. Is that not correct?
May I briefly answer your question?
Yes.
While this is a personal jurisdiction question, I believe that your decision on the personal jurisdiction issue is outcome determinative. And if you rule for defendant and allow this defendant to isolate himself from liability in this way, this case will be dismissed and we will be denied a remedy. Thank you.
All right, well, thank you, counsel. We will take it under advisement.
Okay, the judge is going to deliberate, and Dean Wilson, we also have room 237 for you guys, if you're just rather step across there instead of walk back to the dean's office. Refreshments should be outside. Let me ask you to do me a big favor, okay? Go out there and get refreshments. Don't make a lot of noise in the hallway because they've got many trials going on in the courtrooms. And if we make a lot of noise, I'm going to get in trouble about it, and I'm going to throw you under the bus, okay? So please keep it quiet. You can bring your stuff back in here, but the second request is clean up after yourselves because they'll be back in here in the morning, and I'll hear about that too, okay? So we'll take about 15 minutes.
Please be seated. Back when I was coaching, the worst thing that could happen was for the judges to want to talk and talk and talk when everybody wants to know one thing, right? Yes, everybody wants to know one thing. We did spend a lot of time talking and going through what we thought were good, pros and cons, and things that you did well, things that we would hope that you would improve. But overall, we all to a person thought that you all did an excellent job. The decision was as close as it could possibly be. We had a 4-3 decision. And the winners of this year's competition, or this term's competition, is the Petitioners. Before I turn it over to Walker, I just want to emphasize how good all of you were and how hard we had a hard time deciding. So congratulations to all 4 of you. And I'm going to turn it over to Walker.
Everyone, I'm going to get us started on the awards portion. We're going to begin with the team awards by recognizing our semifinalists, runner-up, and champions. Semifinalists, when I call your name, if you want to come down and receive your plaque from Nathan. So we're going to begin with team number 2, Lily Reed. And Aaron Konchenka. And team 17, Callum Harrelson. And Matthew Topfest. Now our runner-up, Keegan Kuhn. And Matthew Zen. And our champions this year, Kate Sparks. And Kaya Helmer. The next awards that we're going to give out are going to be for our advocacy awards. The way that these are going to work is we have 1 through 10. This year we actually have 1 through 11 because of a tie. So when I read off 4 through 11 for advocacy awards, those are not going to be in any particular order. It's just going to be randomly. So when I call your name, 4 through 11, if you just stand to be recognized, and then 1 through 3, we will announce an order. And if your name is called for 1 through 3, if you would come down and receive your plaque. So moving into that, not in any particular order, Callum Harrelson. Evelyn Morey. Daniel Whittington. Hattie Krowecki. Taylor Brown. Dylan Evans. Matthew Zen. And Madison Solis. And now for our 1 through 3, again, if you could come down and receive your plaque. Our third place speaker for this year is Justin Garber. Our second place speaker for this year is Charlie Delmonico. And our number one speaker for this competition is Kaya Helmer. That's all I have to give out. Thank you all for coming.
Thank you, judges, again. Thank you guys for coming down from Baylor. I appreciate it very much. Appreciate the firm support. So, I think there's going to be, Nick needs to take some photos out in the, before the Bad Dog statue. So if you receive an award, please hang around. Thank you, guys.
Thank you.
You bet.